And I also had a question to Mr. Dimitry, actually, which I'll probably ask later. So first, thank you very much for your question. Actually, wrote a monograph like 5-6 years ago about the promotion of democracy and the rule of law in Central and Eastern Europe in the context of the pre-accession, basically analyzing what can be done under the framework of EU treaties and secondary legislation in terms of improve the situations and the situation in these countries. And there are very interesting picture emerges because the European Union clearly has much more leverage for the outside compared with the inside, the member states that are already in. So the level of competence that the European Union enjoys in external relations, in terms of the promotion of human rights, rule of law, etc., is much higher, much broader than on the inside. What Mr. Tsilevich told us is actually absolutely true. So the international law on citizenship is as clear as day in saying that the states in international are absolutely free to decide who their citizens are. There are tiny exceptions from that principle. So what we have in terms of developments in EU citizenship that today is very, very new. The Rottman case is from 2 years ago. Before that, it was absolutely not clear where the border lines of EU competences are. So it was not possible to say whether, actually there was no practice, there was no law, whether the European Union can direct citizenship legislation of any member states or acceding countries. Nevertheless, because of this discrepancy between what the EU can do externally, much more than internally, and internally, once again, the European Union tried to solve the issue. So the European Union relied heavily on the practice of other international organizations, indeed the Council of Europe and plenty of others, in order to push the member states to be, especially Slovenia, Latvia and Estonia, to change their legislation. And there the emphasis was made on the mid to long-term future. So the emphasis was made on the nationality for the children especially, and on getting rid of the windows of naturalization which we already mentioned. So in that, the European Union was very successful. So both countries were speaking about Estonia and Latvia changed the law. It was a much more modest success actually in Slovenia. But then if we make a broader comparison along the issues which were presented so skillfully by Mr. Tsilevich, actually a cleavage emerges between the way how the European Union behaved in the context of different member states. So if we take the issue of Roma citizenship in the Czech Republic, that one was solved entirely because the Commission simply made it an absolute condition on the Czech accession to the European Union to resolve this issue. So it was made absolutely clear to the Czech Republic that they will never make it as a member state of the European Union if they have stateless Roma roaming around. So the Czechs didn't have any other option but to change the law. And once again, the European Union was not prevented from doing this by the lack of internal competence. So what emerges is already, although the European Commission actually advocated, or officially pledged, that to use the same approach to all the member states trying to accede to the Union, in fact, a huge difference a discrepancy in treatment can be observed with regard to the three most problematic states concerning statelessness and the Czech Republic. So the Commission was not actually entirely true to its own words. And I hope this answers your question. And I also have a small clarification regarding the Spain versus UK case, just a minor one. Of course, the Memphis case was about those who are covered by the declaration, so those who were European citizens. The trouble is that, the good thing is that in the UK there is no overlap between citizenship and those who can actually vote. So voting rights are not viewed as citizenship rights. And this is something that was not uncommon 100, 150 years ago all around the world. And the US is a good example of the time. You needed to promise that you were interested in staying in the US long term in order to acquire full voting rights and full rights of political participation in the US once you landed on the Ellis Island. So if you told them, no, I intend to be a tourist, I will stay here for a while, like Dvorak, for example, then I will go back, then of course you will not have those rights. So the UK still has this concept for Commonwealth nationals. All the Commonwealth countries' citizens have full representation rights in the UK. They can run at all the levels. They can be members of the House of Lords. They can be members of the House of Commons, and they can also represent the UK in the European Parliament, which is also essentially important. So the Spanish claim actually didn't go to a minor point about Gibraltar. It went against the core of how the UK understands the connection between political representation and citizenship. So Spain was basically arguing that European law can be used in order to stop this age-old tradition of opening up the political process to those who don't have a formal status of a citizen of a member state. And of course, this would be an absolutely wrong reading of European law, which limits the rights and basically curtails our citizens rather than opens up new horizons. And that's why the decision of the court was widely welcomed. Thank you.